Hello everyone, my name is Arturo Gonzalez. I'm a corporate counsel for the Lego Group. I do intellectual property. I'm in charge of Latin America for the protection and enforcement of the IP rights of the company. And today I will just talk a little bit about the new law, the new industrial property law that is being discussed in the Senate in Mexico right now. So I just divided the most important points in 4 different areas that we are going through all of them right now. So before, I think that the first one, it's gonna be trademarks. So the most important thing is that the new law does not contain touch, position, or multimedia marks. Also, some reservations of rights are excluded from the non-registrable trademarks catalog. Requirements for notorious and well-known marks are simplified, which is something good because as the law is right now, you have to prove a lot of, you have to submit much evidence to get a declaratory from the authority. Also, multi-class trademark applications are incorporated to the law. This is also something that is very innovative because in most of the South American countries, you are already allowed to file multi-class applications. So there's a backlog in Mexico for that possibility, but now you can do that with the new law. Also, office actions will be limited to one office action. In the past, you can have like either 2 or 4 office actions. Now the new law limits the time to respond to 2 months instead of 2 plus 2 months. So as the law is right now, you have 2 months to answer an office actions and a grace period of 2 other months without paying only paying government fees, and you can answer the office action. Now you will not have that possibility. Also, trademark applications can be laid in abeyance when a contentious procedure is duly filed. The law defines bad faith for non-registrable trademarks. The requirement for recording a license agreement before the trademark office is deleted. So those are the most important points for trademarks. In patents, what I have is the validity of a patent can be extended 5 more years. It means 20 plus 5 years. When the process lasted more than usual. So this is something that I think it will give the applicants or the patent owner more time to use the patent even when it's already granted. In terms of litigation, I think that the law is incorporated like most of the points that were discussed and before the Supreme Court or before district courts. So I think that I will go in each one of them. So first, the deadline to submit a power of attorney is limited to 5 working days. Also, in preliminary injunctions, it will not be necessary to show ownership of a trademark registration. This is very important because before non-traditional trademarks, whenever you try to file an infringement action on the grounds of infringement to a non-traditional trademark, for instance, trade dress, if trade dress were not incorporated to the law, you have to struggle with the authority to have a preliminary injunction granted. Also, trademark office will be able to invoke ex officio prior use of trademarks when dealing with nullity actions. Partial nudity is also incorporated for trademark registrations. However, the plaintiff will not be able to argue the same causes argued in an opposition procedure if it was denied. Infringements to domain names are included in the catalog of infringement causes, and damages are increased to 60%. Nowadays, you have 40% for damages. So the addition of this 20%, I think it will be good for the infringed parties. In other points, I have that alternative dispute resolutions are incorporated to the law. Recording films in a movie theater will be considered as felony in terms of copyrights, even when I think that that point should be included in the copyright law and not in the industrial property law that only deals with trademarks, patents, and other kind of rights. So mainly, those are the main points of the law. And nowadays, the law is being discussed in the Senate, and we think that the new law will be valid. The new bill will be valid maybe June this year. So we as an association, are right on time to contact the senator and maybe start like discussing the position of INTA regarding this new law. So since I'm based in Mexico City, I'm already trying to contact the senator in order to discuss this and get a good outcome for association.